Okay, so chapter 14 then. Now, as it says, there are a lot of different sets of laws or rules that would be relevant as far as different aspects of evidence are concerned. But as you can see in 14.2, the basic point is that if you've got relevant material, then it's going to be admissible unless some sort of rule excludes it. So yeah, unless and until it is excluded by operation of law. I think the key law there is the 2009 Evidence of Civil Proceedings, Guernsey and Ordinary law. As you can see, though, the court has a general exclusionary discretion. And again, and this is something that's fairly typical in a lot of legal systems, the parties are able to agree on the admissibility of evidence at any time. So generally speaking, if parties agree, then there is no issue there. Yeah. 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 Well, moving on. Yeah. Mm. Yeah. So, yeah, all right. So admissibility is a matter of law. We would have expected it to be, so it's for the bailiff or whoever the judge is to determine that. Hmm? Yeah. Yeah, 1865 is important. Mm.
Which one's doing it?
Yeah. Well, I mean, I think the 1901 and the 1908 ones. I don't think they're that much day-to-day significance, really.
I nearly had to use the 1908.
Did you? Really? Yeah, yeah. Well, that's one of the things it's specifically designed for. Yeah, yeah.
But I think that's the only point, is that you just need to be aware there is a provision that if you preserve evidence, that's, yeah, there is a procedure in place to do that.
But I mean, you could have just got a witness statement and then served it that way. Really?
Well, not if you want the person to be able to cross-examine them.
Oh no, no, obviously, that's a feature of that. Yeah, because you can go through the whole kit and caboodle, basically. Yeah.
But yeah, you can serve a witness statement.
It's going to affect the weight if you can't cross-examine that person. Yeah. Okay. Right. So under the 1865 law, so this will help Laurent, everyone's presumed to be competent unless there's some particular reason. And you can see again, it's picked up by the 2009 law. So not competent, meaning someone suffering from a mental or physical infirmity or a lack of understanding. And my point is that just kind of takes us around in a circle, really, but there we are. You're not incompetent merely by virtue of being related to somebody in the proceedings. And that was just very weird to me that anybody might have thought that, but obviously that had to be specifically ruled out. Mm.
You can't give evidence.
Oh, double jeopardy.
Yes. Yeah. Yeah. Oh, yeah. There's no gender imbalance in there. Doing things. Yeah. Breaking laws. Yeah. All right. So children are competent, as it says, if they satisfy the criteria in yet another law that didn't make it into the list. So there's another one for you. So sufficiently intelligent to justify the reception of his evidence, understands the duty to speak the truth. And that, I think, is just basically lifted straight from the English provision on that. I note that I started repeating myself in the text, so I need to amend that. Anyway, hearsay, quite a lot on hearsay evidence. You guys appear to still have the, what I'm going to describe as the traditional definition of hearsay. So if you have learnt about hearsay evidence in England and Wales since 2004 onwards, this is an easier definition. You don't have to worry about the intention of the person that made the statement or anything like that. It's just straightforward. It's a statement made otherwise than by a person while giving oral evidence. In those proceedings, it's being tendered as evidence of the matter state. So in other words, for the truth of what it says. Yeah. And as you can see, very simple. Section 1 of the 2009 law says that in civil proceedings, evidence not to be excluded on the grounds that it's hearsay of whatever degree. Okay. Don't think there's anything else that one needs to say about that, except to observe that civil proceedings is defined as encompassing every stage in civil proceedings where you might end up calling somebody as a witness. So perhaps particular interlocutory hearings, anytime you need to do that, then you're okay. So the only slight caveat on that is the point where, as it says, if there's, I guess, probably multiple hearsay, more than anything, but hearsay shown to consist of or to be proved by means of a statement that was made by someone who wasn't competent to be a witness at the time that they made that statement, then that won't be admissible. So it's really applying your competence test to the hearsay statement. So notice, that's an important consideration under, I think it's section 2 of the 2009 law. You have to give notice. It has to be reasonable and practicable in the circumstances, and it should include particulars of the hearsay evidence, although again the parties themselves can take control of this process and agree to dispense with the notice or waive, the other party can waive the necessity to have a notice, and again under section 2 the court itself can relieve the party that wishes to adduce the hearsay evidence from the need to serve a notice if it seems to be necessary or desirable. Yes. Okay, so, oh yes, hearsay evidence at trial then, 14.8. So we've now gone into the 2011 rules, hearsay evidence to be given orally by a witness at trial. So there was somebody maybe in the witness box who is repeating something that they have heard, being told by somebody else outside of court, or perhaps even read in a document somewhere. So as it says there, alternatively, that it's contained in a witness statement will be used in place of that person being called as a witness at trial, then the notice requirement is addressed by serving the witness statement on the other parties. And if you are in fact using a witness statement and you don't intend to call the person that made that statement to testify at the trial, then you might not have to serve notice, a hearsay notice, but you have to serve a separate notice saying they're not proposing to call the maker of the witness statement. Establish your reasons for doing that, and of course that you've got various time limits to comply with as far as that's concerned. If there's anything else I wanted to say about that. Oh yeah, just as a for instance, there's a case that's referred to in one of the footnotes. It does come up a few times later on. It's quite an interesting case, just I think because there's just so much reference to the evidence in there, and it kind of goes on and on, pages and pages of evidence. I don't think I've actually got it down here, but the Cooney against AFR executors.
The Gordon case.
Yeah, but yeah, it's interesting. But I guess in this particular context, it's interesting because it's all about, what is it? I think in this particular citation, it may occur elsewhere, but this particular citation is the hearings was to establish the domicile of the testator, the late Mr. Cooney, yeah, there was a lot of ambiguous material as to where he might have been domiciled. Could have been in England. It could easily have been in Jersey. It might have been in Guernsey. And I think the two front runners there were Jersey and Guernsey. And there were going to be different consequences because of the different inheritance provisions, depending on which way the court decided that particular issue. He was a man, I don't want to disparage him in any shape or form, but he was clearly a man who liked to stay on the move, if I can put it that way. Not necessarily being terribly prompt in informing the relevant tax or social security systems as to when he arrived or when he left and things like that. So as I say, there's a certain opacity in terms of his life, really. And so the court just observes in that particular judgment that one of the parties to the litigation was his widow, Nora, and that she'd put in a witness statement, or her lawyers had put in a witness statement for her, but she wasn't being called. They weren't going to call her as a witness because supposedly she was in England at the time and unwell. Various bits of evidence were being put forward. The court wasn't very happy about that and said, well, obviously there's evidence to suggest that she's ill, but none of her doctors appear to have advised her that she's not fit to travel or anything like that. So she hasn't exposed herself to cross-examination, and her evidence will be viewed accordingly, basically. No doubt there have been lots of conversations that she and her late husband were party to that could have shed quite a lot of light on his intentions and that sort of thing, but she had chosen not to put herself at the court's disposal, so that was that. But it's an interesting case. Okay, so as it says there, 1411, kind of comparison to what I've just said. If you are proposing to rely upon hearsay and you're not intending to call the person who made the initial statement to give oral evidence, anybody else can apply for permission to call that person and then cross-examine them on the basis that the statement is being treated as their de facto evidence in chief. As it says, that's not going to help. If the maker of the original statement is not available, for whatever reason, typically too ill, which was, I think, the suggestion in the Cooney case, or they are deceased. Weight is clearly an important consideration as far as hearsay evidence is concerned. You've got a list in 14.12 of factors that the court can take into account. I think that's fairly self-explanatory. Aside from this, you've also still got certain rules of customary law that have been preserved by the 2009 law. So as you can see in 14.13, admissions, for example, or statements in public documents would have been admissible at customary law, and they still are on exactly the same terms as previously. Evidence obtained before proceedings have begun, and this is something that Heidi, I guess, was referring to there at 14.14, and as it notes there, it's picked up in a bit more detail at 14.29, but there are various provisions which have been used by Guernsey courts for obviously a considerable period of time. Credibility at 14.15. Obviously, that's the sort of thing, although it's an ancillary issue, collateral issue, it will quite often be the subject of an attack through cross-examination, if that's possible. Of course, with hearsay, it's quite possible that the maker is not available to be called, and therefore they won't be open to cross-examination like with Nora Cooney there. So there is provision then for evidence of any inconsistent statements to be produced there, and indeed call evidence that might have been used to undermine the witness's credibility had they been available. So as you can see, the rule of finality on matters of credit still applies. So you're kind of limited in what you can do to that extent. There we go. Yeah. Privilege. Privilege against self-incrimination, 1416. Picked up again, going back to the 1865 law, but it has been limited. So there's been an amendment effectively made by the 2009 law to Article 25 of the 1865 law, such that the privilege only applies where the allegation or accusations of crimes having been committed that would be contrary to the laws of Guernsey or Alderney. And again, it's silent on Sark as far as that's concerned. Maybe you can't commit a crime on Sark, I don't know. Fairly sure you can. Yes, yes. So that's it. That's about as far as it goes. But again, coming back to a point maybe that Julie was talking about just now, also extends the right not to incriminate one's spouse as well. And interestingly, again, unlike maybe English law, that situation, that privilege survives dissolution of the marriage. Yeah. So yes, but that it subsists post dissolution. Yeah. Yes, you might waive the privilege. Yeah. Well, I suppose that you see that begs the interesting question of whose privilege it is. Yeah. Well, yeah, I mean the excuse me, the public interest in having this kind of spousal privilege obviously is to preserve marital harmony, isn't it? Plus this idea, I nearly said fiction, this idea that husband and wife are a unity, they are one being. But of course that all kind of falls away once the marriage is over, really, isn't it? I don't know. Yeah, I think that's a different law. Well, that may change, of course. Who knows? You got McMafia. That's yes. Yeah. Well, or not anymore. Apparently, not for the UK. What is it? Tier 1 gold visas. That's all. Because apparently somebody just realised that might be used for like money laundering. Who would have thought? Came completely out of the blue, that one. Anyway, all right. So convictions as evidence. Under Section 11 of the 2009 law, a conviction would be admissible to show commission of the offence of which one has been convicted, where that is a relevant matter as far as the proceedings are concerned. And it sets up a rebuttable presumption, which is obviously tactically quite handy. So I think that's probably that. It's the sort of thing that, I mean, obviously there's not that much use potentially, but maybe if you're pleading fraud, that type of thing would be quite helpful. Or if you're in a road traffic PI matter and the defendant's been convicted of careless driving or something like that. Yeah. Okay, so documentary evidence then. Obviously, this is a fairly frequent form of hearsay material coming before the court. But as you can see in 14.19, documents which are records, business records or records of a public authority can be adduced in evidence without further proof of them. But you do need to get a certificate signed by an appropriate officer of that business entity or public authority to state that it is part of the records of that entity. And of course, part of the rationale for this is convenience for the business or public authority in terms of not having to rock up and prove all of these things, a bit like bankers' books evidence provisions. And also partly because I guess, given as I say that almost always you'll be looking at hearsay points with this, the guarantee, if you like, validation that the court is looking for is just the sheer kind of everyday mundane nature of these things. It's not something that's been created specifically for the purpose of the proceedings. So given that the business is probably producing, hundreds, if not thousands of documents maybe on a daily basis, why would anybody have thought to have specifically warped or twisted or inserted information that wasn't reliable in there? So it's just the kind of ubiquity of the information that's the kind of guarantee of its reliability there. There is a point though, as you can see in 1419, absence of entry. So obviously just looking at the record is not going to tell you anything, it's because there won't be anything there. So it might be, the example I've given there is maybe the issue of a permit, like having a TV license. Do you have TV licenses in? Yeah, okay, all right, just thought I'd ask. So yeah, something like that. Although, of course, dealing with that tends to be a kind of quasi-criminal matter. But as you can see, proved by, there's no point in adducing the records because there's nothing there. So adducing an affidavit from the relevant business or authority there. And specifically, Ogden tables can be proved by producing a copy published by HMSO, or indeed in any other manner that the court considers to be just and convenient.
If it helps with we have issues now. That's really kind of organised we are sometimes, but some people all country laws, would you like to get that in minutes? Obviously, the reviewing this last week. I thought this one looks like the 62.
A and B. Good.
Not just your film.
We'll see.
Right, okay. On that bombshell, yes. Right, expert evidence then, 1421. So this is dealt with in sections, primarily sections 18 and 19 of the 2009 law, although there are also elements from the 2011 rules picked up in there as well. So section 18 gives the ability to make rules, and as I say, 2011 rules part 2 are the relevant ones to look at there. Section 19 of the 2009 law says that where a witness is qualified to give their opinion on a relevant matter, that will be admissible into evidence. But the courts have understood that in terms of on a relevant matter, as matters have to be outside the knowledge of ordinary people. That's just a bog standard requirement, effectively. I have noted the Thompson and Lanuri litigation there. I don't know if there's anything in particular. All right, so there's a little bit in there. Got actually quite a nice little section on expert evidence from paragraph 172 of the judgment onwards. You've got a little bit in the head note there. In cases such as this was a personal injury crash between two speedboats, apparently. But where medical evidence is relevant, important that counsel properly identify the issues requiring the presentation of expert evidence. Very careful to guard against uninhibited searches through a victim's medical records. It's almost coming back to your privacy, sorry, your disclosure point again. So as to avoid an invasion of privacy, evidence has to be relevant, such that it will assist the court in understanding matters outside the knowledge of ordinary people. Counsel should also guard against introducing expert evidence which in fact would offer no practical assistance to the jurats in determining the factual issues of a case. And at the risk of stating the obvious, Thompson predates the 2009 law.
And you would expect consideration of all things that they're going to come on to in terms of signal or secret witnesses, courts coming, which we have to
Oh, we had all that yesterday. I don't know who came up with that label. It's just wrong. Yes, all right. So, all right.
That's a memorial, that's on the
Yeah, all right. So, yes, moving on. The 2011 rules, as I say, picked up in part 2. So, as it says there, going back all the way to the overriding objective, courts under a duty to save expense and deal with cases in ways that are proportionate. So, Rule 8 of the rules says that expert evidence is to be restricted. In the sense, therefore, it's kind of sharpening up some of those observations from Thompson and Lanuri against Masterton. So, in order to call an expert witness, always necessary, subject, of course, as ever, to the parties agreeing to do something different, always necessary to obtain permission from the court. And the court stated in 2014 that it would be useful to look at principles that have come into play under Part 35 of the CPR, which is a relevant set of provisions as far as expert evidence there is concerned. So, as it says there, an application for permission to use expert evidence should identify the relevant fields of expertise, which gets us again back to the point about, is it a matter which is outside the knowledge of the court? Also, try to nominate a specific expert. Also worth noting there that the court can, and I think probably quite often would, place a cap on the amount of the recoverable fees associated with the expert. Single joint expert under Rule 13. This was something that Mark talked about yesterday. And as you can see then, the court can give a direction on that. The parties may well be able to agree on who that expert should be, but if they can't, then they should provide a list. Maybe they provide different lists per party, and the court makes its decision. As it says, the court can direct any other manner to be used, but I can't personally think of an alternative to having some lists. They can play conkers with each other, I suppose, but lists appears to be the best way to go forwards. Interestingly then, if you do have a single joint expert, each of the relevant parties can give their own instructions to the expert. As it says, parties can be required to pay some into court to cover the fees, but they are in fact jointly and severally liable to pay the SJE fees. However, of course, at all times, the expert's primary duty is to the court. They are not supposed to be a hired gun, so that's important for them to realise. What else do we need to think about there? Yeah, so the expert has to state in his report he understands his duty to the court. He's complied with that. That's just pretty standard stuff there, really. And in terms of the form of the expert evidence, then usually there'll be a written report, fairly obviously, because we want that to be disclosed. We want the parties to be able to consider it. And I don't think there's anything else we need to say about that. Where we have an expert who is not a single joint expert, but the more kind of traditional form, then as you can see at 1425, other party or parties may submit written questions there. If we do have an SJE, then everybody may ask written questions about the report. So it says usually only one opportunity to ask those questions should be put within 28 days of being served with the report, and the purpose is to clarify that. However, the court has the power to vary that limitation, or again, the parties by agreement can vary that. Any answers that the expert gives to those questions will form a, if you like, a supplementary part of their report. If we don't get an answer from the expert, then there may be problems there, as it says, in terms of relying on the evidence, maybe in its entirety, possibly that even if you get costs order, that you won't be recovering the expert's fees. Mm-hmm.
But basically, the picture is a viewing of the principles that we have done it in. And rather than just put the mostly technical. So you would need to line up the experts. We have a really technical input into it. And I just think the character of need to warn your expert on witnesses that they're not supposed to speak to the court. Unless spoken to, and it should be the basis for the evening who especially for that brother class and the logistics where it was tramping, it was very just it was tramping over people's gardens and sand dunes and stuff. It was fascinating. Especially because you're in full court, right? One of the but not context, I can see that the expert would be getting asked questions. We have to make sure we grab everything together practically, and then make sure we address the question to the expert before he's got basically the actual responding request for clarification or whatever. That has to be very carefully planned for these reasons, and need to know your location so that you can relate those points.
So it's like a site.
And is there a deputy record present who takes a note or carries the recording equipment?
I was so busy trying not to fall.
And you're walking around talks.
Yeah, well, you take your top off.
Just the purple.
Yep.
It's like a
Harry
Presumably they might take photographs or something.
Yeah.
Go back to the bus.
Yes.
I don't think it's very close. I think it's one of those things where obviously you'll know if it's a case where it's appropriate. And actually, it's from I remember one other one which was like which was much more straightforward. You just walk in and work out where they are and so I think you just ask the court to fix the distance. You could have it in the plan, as well, for example, you just use over the floor On a very practical level, if you ever have a judicial review on the planning matter and it's endemic to deal with, he will indicate that, of course, he advise the planning department when he was at law officers, and would you like him to recuse himself? The polite answer, of course, is no, but the practical answer is yes, because he's not going to be working in the offices either, or experienced as a planner, because he knows and understands how to do
Do you say yes, please?
and the clients are uncomfortable anyway, and that's obviously one of this is the right moving because if he's not making it, but it's just, you know, he's literally question answer, but if you've got somebody who's more intimately with the planning, understands their difficulties, he's not coming to the code analysis with the way he has another judgment.
Yes. Coming back to the photography point, yeah, no, coming back to the photography point, actually, you reminded me that, yeah, a colleague of mine from City, who still practices from time to time, had to go on a site visit, I think probably about a year ago, in a very sad fatal accident matter. And that was kind of similar. Everybody rocked up in formal gear. But it actually was covered by the local paper. So they had a photographer on hand, and yeah, you can go onto the local kind of paper website and see photographs of people mooching around. Yeah. Mm. Yeah, yeah. No. Yes, right. Okay, so use of the report then, 1426. So as you can see, if a party discloses the report by the expert, then anybody's at liberty to use that. It's really, I guess, a specific example of the idea that there's no property in a witness, effectively. As it says, failure to disclose will mean that the report cannot be used, and the expert could not then be called to give oral evidence unless the court, for some reason, decided to allow that. Discussions between experts can be directed by the court. This is not, I think, intended to be the hot tubbing reference here, but some kind of pre-trial discussion there. And as you can see, the court can specify the issues which the experts are to discuss. The idea then is to lead to some kind of outcome statement that records the points on which they agree and those on which they still disagree. However, although that may be the expert's view, that isn't binding on the parties themselves unless they have already agreed to be bound by the views of the expert. 1428 takes us on to an interesting distinction between witnesses of fact and opinion evidence. So opinion generally, of course, has to be expert opinion, which we just looked at, but the rules also identify that a witness of fact may give opinion evidence simply as their way of kind of communicating factual circumstances that they have perceived themselves. Classic example about, you know, he was drunk. How do you know? His eyes were glazed, his speech was slurred, he couldn't touch the end of his nose with his eyes shut. Dum-de-dum-de-dum. Which I think in America is called, was it the field sobriety test? Not that makes any difference, but yeah, that type of thing. So it's really still factual evidence. I guess the point there is, if you have a witness of fact who seems to be giving their opinion, then we need to try and pin down the facts that underlie that. Yeah. Even something I think as banal as the red car was traveling very fast. Well, that's an opinion. Yeah, so you need to kind of unpick that a little bit further. All right, obtaining and preserving evidence, which is getting us back to, I think, Heidi's point. This is where this is coming in then. So conducting the examination in writing of witnesses a future, so in view of a future trial, maybe an appeal in a civil case, So you've got the 1908 loi as far as that is concerned. So you can see that the court will nominate a jurat as commissioner, typically, and the questioning will then be done in court. It's sworn evidence. The questions are recorded, the answers are recorded, usually, I guess, by the deputy greffier. Each page is initialed, excuse me, and then everything is signed off by the witness, presumably, although I didn't find this in the relevant rules, having been given a chance to either amend or delete or add anything, which would be the normal procedure. Anyway, so objections must be taken before the witness is sworn. It won't stop the process from taking place, but it will effectively record that challenge, and then the court will rule on that subsequently. So we can have chief, we can have cross, re-examination where that seems to be appropriate. And again, coming back to Heidi's point, then if you've had at least the opportunity to cross-examine, then that may well add to the weight to be attached to the evidence that's been recorded. As it says in the rest of that paragraph, then, since the court tends to prefer or see the best evidence as being live oral evidence given in the courtroom, actually in the proceedings themselves, that procedure is only likely to be used where it can be foreseen that the witness probably will be unavailable. And you've got this reference to the ordinance of 1931. You can use that procedure where the witness is about to leave the island, is at risk of dying, or any other valid reason. Just on that point about leaving the island, obviously 1930s audiovisual technology wasn't quite as advanced as it is these days, so maybe it's less significant in that particular context. Okay, I don't think that there's anything else that we need to bring in there. You've got the 1924 supplementary law there, as it says, to make provision for perpetuating evidence that might be material in the event of proceedings being instituted in the future. So that's a very kind of forward-looking provision there. My observation is that generally speaking these days, unless you have someone that has got some terrible illness that will incapacitate them from testifying, or indeed prove to be terminal, before the time comes for them to give their evidence, you probably don't need to resort to these procedures. All right, evidence by live link then, obviously for those who are elsewhere. And there could be a situation where it's not simply that they are outside of the bailiwick and it's not practicable to bring them back. It could be someone that's here, but perhaps has been severely struck down by an illness, maybe is in a nursing home, and it's just not practicable to bring them to the court. Yeah. Yeah. Okay. So as you can see then, at 1433, you've got this 2011 ordinance providing for live link evidence, and the court has the power to direct that specific witness, which can include one of the parties to the proceedings, shall give their evidence from a remote location. And all that means is somewhere other than the room where the action is currently, or the trial is currently taking place. So it could even be from another room in the building if there's some kind of, this is like a special measures direction of some sort going on there. So I don't think there's much else to say as far as that's concerned. You've got the conditions there in 1433. In 1434, court can attach ancillary requirements, so that might include, as it says, they're requiring a party to find an appropriate remote location. And I guess Elaine's just given us an example of that with the solicitor's office in England. Of course, you have to have the facilities for doing this in the location as well. And then 1435, the 2011 ordinance provides that a witness who is using a live link is deemed to be physically present. So theoretically, at least, the court could exercise its powers to secure witness attendance through a witness summons, assuming that wherever the remote location is, it's within the jurisdiction of the court to enforce the witness's attendance. It's meant to be sworn evidence. That may, of course, be on oath or by an affirmation. And the witness can produce any document or article which is in fact in the courtroom by identifying it, because obviously they'll have it's really a two-way link. They'll be able to see what's happening in the courtroom. And indeed, it may be that the article itself is in the remote location with the witness. And again, if you like, the same provision applies there. They can receive the image of a document or article that is with the witness. And I guess from that point of view, it's just whatever seems to be the most practical way to deal with that. If it makes sense for the witness to have the material or the object with them, then that can be done. So all the same rules about compellability, privilege, yeah, exactly the same. And then just a last, and I don't know, I kind of think rather obscure point really, the parole evidence rule. So yeah, 1865 Loire, in the case of a written agreement, no evidence from a witness, this of course means no spoken evidence from a witness, shall be admissible to either contradict or extend the contents of the document that contains the agreement. Now, according to the commentary in Laws of Guernsey, it's been said that there are exceptions to this, or the equivalent rule in England. A colander full of holes should present no obstacle to a just result in any given case. Do I want to? I do. Yeah. Want to talk about Brownstone? Let's see. Well, all right. So the Brownstone insurance is a very short judgment, 43 of 2004, and you've got paragraph 6 there. The court, which for those that are interested, was the Lieutenant Bailiff, Catherine Newman QC, back in 2004, says 2 exceptions to this parole evidence rule are of relevance. One is where a claim is made to rectify a document, evidence will be admitted of mistakes in the document. And the other is where it's an interpretation or construction point. Court has to construe the meaning of the words used in an agreement or any other utterance. The court will look at evidence of the surrounding factual matrix. So there you go. So not a massive point as far as that's concerned.
Question.
Question one.
It just helped to focus the mind. Yeah. Does it come up with this? Does this come up in these? I mean, it must be. What a good question.
I think it's not some of these about talking to you get back to
That's what we do.
yeah, post 2009 because I started looking at mass presentations. But it didn't come up on a wheel in that time. Especially, I suppose if you're asked,
Yeah. Again, for what I think is, and it's quite a chunky case, but I've mentioned it before, and as I said, I think there are just some cases that lend themselves to quite a close reading. And we mentioned in the previous weekend the Jeffcoat and Spread Trustee judgment, and that has some quite good points, some practical points. as far as evidence is concerned. There's a nice illustration in paragraph 145 of the privilege against self-incrimination, which we've just been looking at in this chapter. 145. It is the 42/2014.
Sorry.
42 of 2014. So it's October, 31st October 2014.
What did it say?
What did it say? Right, yeah, sorry, you want your paragraph 145. Well, one of the witnesses is Mr. Kehoe, interesting individual. It says, paragraph 145, several aspects of Mr. Kehoe's evidence are somewhat unusual in civil proceedings. This is a great understatement. In the course of forceful, brackets not surprisingly, cross-examination, he calmly said that he had been a kind of heavyweight enforcer, brackets my words, for Mr. Nicholson, and even after being informed of the privilege against self-incrimination, he said that he had at times broken the law in achieving results which Mr. Nicholson wanted, and had issued threats, albeit short of violence. He agreed that he had threatened Mr. Parker, then denied having threatened Mr. Nicholson or Mr. Bryan. He also, paragraph 146, admitted of his own initiative going to see Mr. Bryan and his wife socially and covertly tailing the conversation. So Mr. Kehoe accepted that he had been lying to Mr. Bryan by saying there might be some reward for him and he wouldn't break his trust, but said matter-of-factly that you had to say what was necessary to get the truth out. So there's a good lesson for all cross-examiners. But yeah, so yeah, privilege against self-incrimination there. And there's some interesting points a bit later on, I think from paragraph 1, I won't read them out, but paragraph 172 onwards, the Lieutenant Bailiff is going into some other points, but specifically to do with witness statements, which I think will be quite interesting to have a look at there. Okay.
My favourite witnesses in the room was called Psycho Adams.
Was the psycho in quotation marks?
I think he was exactly part of his
Right.
name. So then it was the 2nd of January, 2007. And the police at 5 years after.
Wow, yeah.
Well, there was a line to it.
All right, yeah. So yeah, there's some nice examples of, if you like, how the court forms views or gives weight to evidence, and obviously that's tends to be quite a personal matter. But there's an interesting point here where the Lieutenant Bailiff says, in short, whilst this Mr. Jeffcoat, I think this is the late Mr. There were two of them, his father and son, but this is the late Mr. Jeffcoat, who the elder father had died by the time of these proceedings, but says, in short, whilst I would not go so far as to use the words greedy or tight, Mr. Jeffcoat certainly had tendencies to be careful about money. But anyway, there we are. Yeah. Okay. So yes, it's funny. In some cases you read, there's almost, you don't get any sense at all. In other cases, you really get the kind of full. Yeah. 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 It's kind of one. Yeah. I don't know, but my feeling was that if I'd just been sitting with my head in there, my hands going, why? Why did we let this come to court? Anyway. All right. How are we doing for time? Steaming along. Yeah. Yeah. Right. Oh, another one? No, that's fine. No, I mean, I think we're doing fine for time. Yeah, yeah. I mean, So, you know,
All those feedbacks.
yes, yes. Well, you presumably you're saving some for next weekend. Yeah. Yeah. It's well, yeah, interesting, very interesting. No, I mean, I've not. It's yeah, yeah. No, he's fine. He's fine. I know all about his recent purchase of a motorcycle for his son, so that's good. His negotiation skills. Yeah. But no, I've been having fun and games. Oh, let me pause. Fun and games with. Right. Okay. So, trial process. As you can see, I don't really have a lot to say about trial process. But one point, I guess, is open access and to the proceedings. That is the kind of default position. And I did note in one of the footnotes the Chengwas and Hamadani from 2015, paragraph 53. And what the court had to say there was that at the conclusion of argument on the respondent's application, we directed that the appeal should continue in open court, rejected the submissions from various people that the present appeal was more appropriately to be heard in private, there being no sufficiently compelling reason to depart from the principle of open justice. This principle, quotes, is and always has been a fundamental principle of our administration of justice, as it was put in IFS Investments and Manor Park, Guernsey, back in 2003, by Lieutenant Bailiff Day. Lieutenant Bailiff Day's judgment in that case was accepted rightly by the parties before us, as setting out in clear and compelling terms the applicable law in Guernsey. Namely, the general exception to this fundamental principle is where justice itself would be frustrated or there has been some statutory derogation. Even then, privacy will only prevail to the extent strictly necessary, the presumption being that justice will be administered in public for all the reasons that were given in the IFS Investments judgment. So that is your general principle, and that would apply both in the Court of First Instance and in the Court of Appeal as well. So as far as the hearing is concerned, usually by the bailiff or deputy bailiff, lieutenant bailiff, sitting with 2 or 3 jurats. So as you can see, the bailiff may sit without jurats. That may be a decision that the bailiff comes to themselves, applying, as you can see, section 13 of the Royal Court Reform Law of 2008. It may be something that the parties themselves have asked to happen. That's that. All of the witnesses the parties intend to call will be assembled at the start of the trial and sworn collectively, unless there's a good reason for them not being there. Again, that's maybe a point, it's not a very important point, but it's a point of distinction with what you're used to in England and Wales, certainly.
Swearing witnesses.
All witnesses at the outset, usually. But quite often we do have started
Yeah.
It's appropriate to one witnesses finding their interviews. And then also we would ask the witnesses to come with some words to leave so that they're not.
Yeah, and there are clearly issues around court convenience, witness convenience, costs, all those sorts of points. Yeah. Okay. Yeah. Again, just coming back to Jeffco, it's the case that keeps on giving. That was a judge alone determination. The judge noting there at paragraph 13 that it was a complex claim arising out of a complex factual history with a complex procedural history. It was for these reasons, and also because of the likely interplay of matters of law and fact, that I agreed to hear the case sitting alone and without jurats pursuant to section 13. So, who was sitting? That was, in that instance, yes, Hazel Marshall. Yeah. Right, okay, what do we need to think about then? 15.3, evidence will be adduced by the parties, but it's not actually incumbent on a party themselves to submit themselves for questioning, although, of course, their credibility, if they've submitted a witness statement, their credibility may suffer, or indeed just the question of them proving their assertions may suffer as well. And I think, yeah, just again, 15.3 references Jeff Coate there. As I said, the father, Jeff Coate Sr., had died. No statement had been taken from him. That seems almost professionally negligent, as far as I could determine there, really. But anyway, there hadn't been a statement taken from him. I think so, yeah. But yeah, so yeah, two examples. You've got Mr. Jeff Coate Sr., who had passed away without any evidence being taken from him. Maybe by way of comparison, again, the Cooney and the AFT executors case where Nora was seriously ill and just wouldn't come to court to provide evidence or be subject to questioning. Bailiff can ask questions of witnesses. The jurats may ask questions, but as Elaine's indicated, it should be done via the bailiff rather than just of their own volition. It's possible, obviously, the normal procedure just applies in terms of chief cross re-examination, so nothing really to pick up there. When the plaintiff has concluded its claim, or his claim, her claim, the defence can make a submission of no case. That could either apply to the entirety of the cause or to a particular issue within the cause. The bailiff may put the defendant to his election. It's not requisite to do that, but it may seem to be appropriate, which is to say, choose between either making a submission of no case or calling evidence, one or the other, effectively. Assuming that either the defendant doesn't make a submission or indeed has not been put to his election, then we move on to the defence case. Yeah.
It was not clear that if we failed, we would then be evidence.
Mm-hmm. I think that's the election point. Yeah, but I think it has to be triggered by the bailiff. I don't think it happens automatically. Mm-hmm. Okay, I'll check it on that. Yeah. Okay, so yes, defence case then may be an opening speech. Obviously, the idea is that they'll call evidence. There might then be rebuttal evidence to deal from the plaintiff to deal with any unforeseen matters. Then, and I think Mark was talking about this yesterday, so defence closing speech followed by the last word from the plaintiff. Bailiff may sum the case up to the jurats. Jurats will reach their decision either unanimously or by a majority. If it should happen that for some reason they are evenly split amongst the jurats, then the bailiff has casting vote. There will then be obviously kind of ancillary matters following judgment in terms of orders for costs, maybe stay of execution, pending an appeal, that type of point really. And that's about it really.
Rob, you know what you just talk about this no case to answer, and they are rare. What can you think of an example? I've seen it, well, I don't know if it's similar, but on a similarly different application a couple of times, but the judge says, I don't need to hear from you, which is an indication that he's already decided that they're not going to win on their application.
Yeah.
Is it that type of, is that the scenario that you think about? Yes.
which is what we are in.
But if you've had no indication from the judge that he thinks
Well,
similarly to you, and you want
sometimes-
that risk of not. That's, yeah.
mm,
Although I have to say the other side, we weren't particularly compliant with the judge, and thought that nonetheless we would do the notice answer mentioned at current level.
That's
Because
why
one of
that's
the big,
where we're at.
some of these things, particularly when we're talking about the Clinton, because there was other litigation going on.
Yeah, no, I can see that. Yeah, that would be, but because you don't have an indication from the judge that he's on the same page as you. That's why they're rare that people don't usually elect.
Yeah,
Unless
I mean-
that I can see in those.
judges, it depends on the judge, as Elaine says, but sometimes the judge will say, the plaintiff closes its case. The judge will kind of look at you rather pointedly and say, do you have an application? Just kind of leave it hanging there. You kind of go, what do I want to apply? Like, I don't know. Shall I make it a speech now, aren't I? But yeah. Yes. Yeah, I mean, I think that's happening more in England and Wales as well, that you're getting that, as you say, kind of the full picture from the start. It makes sense, doesn't it? Yeah.
To the jurors.
Yes.
I don't know if we're going to have this section on the.
Don't think so, no?
Is it possible for the juror, halfway through or following a trial to decide that they just can't decide, and therefore they're not able to make a finding, and therefore either to say I'm not making a finding or I'm just confused myself.
Well, I don't think they'd recuse. I mean, they could recuse themselves, but I don't think they'd do it for that purpose. I mean, they just fall back on the the burden of proof, wouldn't they? Just say if I'm not persuaded, then you lose. Yeah. Mm.
Because it says here, well, because of the whole thing of the casting that it's usually 3 or 5, 3 or 7.
Yeah, there's always a possibility, I guess, that one of them has fallen under a bus partway through the hearing. So yeah.
You've got it in, I think it's an old version, 2008 but you can carry on. As it says, if you've got somebody who's unwell, I can't say I've seen it done, but I've heard of people having to carry on. Yeah. In the jurors, I find that in particularly fact-sensitive cases, you would perhaps want to hear it. For example, if you've got a old lady up against Mr. Arrogant Massey businessman. Yeah, absolutely. I have a juror, but a lot of other stuff. Most of the actual stuff I can't see why. Yeah. There are some really good ones. I mean, people like Stephen Jones who heavily involved in finance. There are also people who can feel really different. And that's of course the point, but
Okay, on to chapter 16. Costs. One of my favourite topics. Yeah. Right, so as is often the way, I guess, in legal systems, the Royal Court has a wide discretion to make whatever order for costs it thinks is just in the circumstances of the case. And of course, the usual principle is that costs follow the event. So if you have been successful, then you should expect to get your costs. As that first paragraph indicates, though, that is a fairly, although it's kind of time-honoured, relatively crude philosophy to use in courts are becoming more sophisticated. So you can have situations of issues-based decisions being made. And I thought I had a case on that, but I'm not finding it there. It's interesting. Okay, that's curious. All right, okay, well, I'm not finding that, but I think the Shaham is a nice example from recollection. That was somebody who had sought to, I think, inherit under a will, some from the will of the late Dr. Ron, which is great name. Dr. Ron, yes, that was the name of the deceased, Dr. Ron. That's all we ever found out about his qualification and his surname. I think. I don't think the court was familiar with Doctor. I don't think it was Dr. Peter or something like that. But no, I think that was his surname, Dr. Ron. Anyway, Mrs. I think Shaham, probably Miss Shaham, I don't know, was some kind of carer or associate partner of Dr. Ron, and she was claiming, and Lloyd's TSB and another, I think this was the executors. So she was claiming money that was in his bank account here in Guernsey, and there were various, should we say, highways and indeed byways that Miss Shaham had taken the court, and it felt that perhaps as far as the byways were concerned, that there should be an issues-based approach to who was responsible as far as that's concerned. So it's a very simple case. It's just quite a nice little illustration of the court taking an issues-based approach. What actually happened was that the byway stuff, I can't remember exactly what the allegation was now, but they were disallowed effectively. So. Mm.
One of the things I don't see it noted in the footnotes, but there's actually on the invest set in 7/15 of 2016, the Court of Appeal, because there were massive cost appeals about the cost of orders to do it. You've got the Court of Appeal then looking at them and deciding what cost there, but also one of the issues there was what the Court of Appeal has in respect to cost and it's there is an issue. So if you're point for us in Court of Appeal in the St. Anne's Trustees earlier on this year, and one, if you are wanting to appeal the cost order made with the questions on its own and independently of the substantive one, substantive orders made, you should also seek the rate of appeal in respect to those cost orders for that cost order, because otherwise, if you just think it's going to be caught up with the main appeal, it will be, and if the Court of Appeal overturns the judgment of first instance, then all the costs are within its purview in terms of review. But if you should fail on the appeal, but still want to change the cost orders, you haven't got that leave there in stage technically you've got an issue. I think to be clear that in the judgment, we certainly argued about it, didn't we? And they accepted that the right thing was that technically you should have the ability to have it on the appeal. So just in case that should come out.
Yeah, okay, so the two key issues, recoverability and reasonableness. So not all costs likely to be recoverable. So you can see footnote, the third footnote there of this chapter draws one's attention to the relevant costs and fees rules, and they have gone up. So I think 2012, you can see capped at an hourly rate of 234. By 2016, the court was using an hourly rate of 245, as referenced in the that particular Chengris case. And you can also note there that the usual position in terms of using outside lawyers is usually disallowed unless there's some particularly legitimate reason for their instruction. So the general practice would be to disallow that type of thing. Which perhaps we can just note what the discussion was yesterday we had about access of outside or foreign lawyers.
I think we all lawyers' fees, whatever practically is everything, or if it comes over the portion of adopting incredibly English approach to the level of recovery costs. So on the standard rate, there has to be really tough on that. Not that there's any help at the moment trying to arrange to bring in financial marshal or external cost process. It's something that's really well covered and all of it is unwritten. But yeah, I think protein is the one to
I think that really sets out the categories where there might be some allowance for the lawyers.
Yeah.
Although I find that so on Broadhead, which always was represented years ago, I can't remember which one it was, but every time I kind of raise it to people, there's always like, yeah, but in this case, it's, you know, there's a good argument there. So in practice,
it is really matters to more English and so yeah, but it isn't
It's a clutch, it's not the final council formula.
yeah, but in practice, would you say that it's more flexible than the eye on the jurisprudence?
I think Broadhead is certainly like the start of a school position. I think in many of the cases you can then roll back to particular facts and say, well, this is again, it's all going on the Hamadani, we've got a different taxation, we've got an uplift in the hourly rate in respect of it. So we got Jonathan Field on his full rate. He then, however, decided that two partners on it was not appropriate, so he knocked my time out and I was doing most of the work. Very much. But I think in practice, in terms of the uplift, you know, when I was arguing that was basically consent, we don't have much review against the jurisdiction respect consent. So again, as a coach, therefore, we're entitled to call on English to give us guidance on what the English position is. I won't go into an uplift because it is so unusual that it can, but it is, I think Broadhead has filled it in quite a bit, to the extent that I think it's possibly pretty suitable for some of those station guarantee.
Okay. Yeah. All right. So again, we just might pick up from 16.1, shading into professional conduct points there in terms of keeping the client informed about the costs, risks, and also, of course, how the costs are mounting up. So you can see there, client needs updated information on costs throughout the lifespan to include a cost-benefit analysis. There are those two bases for making cost, which we've just been hearing about, then standard basis and the indemnity basis. That aside, I think 16.4, you've got a note from 2003 that flexible cost orders were being used by courts here, which continues to be the position. And you've got, as an example, the Roman Zaleski case from 2016, which I think, again, is quite an interesting judgment on a variety of different aspects of costs orders. Not least because there's a point in there, as you can see, on awarding costs on a partial indemnity basis rather than a full indemnity basis. But I think it's clear. And there's also some material in there about having an uplift or considering an uplift to the recoverable rate of costs as well. That's quite quite a nice and relatively short judgment to have a look at on that. Okay, taxation. I think one of the key things to be aware of here, and it's a point that I think was flagged up somewhere and I can't find it now. Oh yeah, in the 11th footnote, whichever number that is, that you've got 1 month to make an application to have the bill taxed. That's 1 month following receipt from the opponent's bill. I can't find a definition of what 1 month means. It doesn't say 1 calendar month in there. So yeah, who knows what that means, but it's been described as a very real trap for the unwary, and therefore presumably not one that we should be looking to fall into. In terms of the court's powers on taxation, it can confirm the claim, it can reduce it, it can disallow it. And then in terms of appeals, as you can see in 16.7, there are different routes depending on who's done it. So if you've had it done by the presiding judge, then it's appealable just on the ordinary basis. Any order by the presiding judge would be appealable. But where it's gone to a commissioner, then it's appealed to the Royal Court sitting as an ordinary court heard by the bailiff sitting alone. Interim payment of costs. I mentioned that when we were looking at interim payments earlier. That's quite possible these days. It seems to happen quite a lot actually these days, interim payments on costs. Chengwis is an example of that, and that does actually kind of pick up the Broadhead judgment as well. And I think also it's referencing Shelton and Barbie, which is another one that's short, quite readable on that. Although hilariously, at one point in the judgment, I think it refers to Shelby, so it's conflated the two parties there.
That says that, yeah, it should be signed.
Because that's the tax you get in England that are billed from the primary partner.
Yeah, but it doesn't say. It was early on this year. I'm happy to send that around, it's just recording what it said in terms of things like that. Although there are the English constitution, you can't open your things in detail ones, these articles for the most part to your recording and a statement of the total that's there. So I don't think he is regarding himself as providing any particular form, but I understand practically how one would.
I think that's, I don't think, I mean, I've not, some of you say that I'm not going to, but I don't think it's such a big point. I wouldn't think it's yeah, I think it's, that's the only thing, that's the only reason I think that may is a requirement of the rule.
Yes.
Whereas here it's not.
It came up in the sense of
Yeah, we were like, was it? Didn't we buy these letters?
Yeah.
So obviously you have to give your files to the taxing master board. It will usually, when you kick off the taxing test, you do your bill, other side object, you out to the court, here's our bill, they object, fix, dealing with LD forward, I don't know if you forward, but you want to look at it. It's power. It's power. Everybody does it every time. It's never hit or it's like power, so you know what. So basically, you actually asking for it. It will tell you the open taxation dates that are there. so we would ask the report to fix timetable for procedure. I would usually suggest what that timetable should be in terms of we've done our bill, please refer them to points within X period and then a period of 5. At the end of that, you should then have your bill of costs with effectively your dates, your narrative, your amount, their objection, your response, and then a column for him openly then just to write what his view is. You do all of that, you may have a skeleton arguments if you are peaceful. He knows them all. Much better than any of us will ever know them. And then what he usually does is gets parties to rules of principle and says, I'm very happy if you want to go through it on my line, but if parties are happy, good points of principle, I will then do it and send it out to the follow-ups. I'll deal with them, and then issues you with your account back with very nice out of the all the different lines telling you how you're going to get, and then you've got the nice job of having it. And we do have to look at we do have to
What about the cost of taxation?
Most of the concept.
Within about 10 grand of the overall of the offer that had been made by the other side, we decided that overall circumstances that we could consider as well. Every year's own cost.
Right, and you can have like many cost cards. So you can have good job without prejudice.
Yeah, absolutely. And that one took into account the that had been made in determining that particular point. Well, we did get the course of English cost draftsman preparing the bill of costs, and I have to say I found there it goes to that much less than we do usually charge a percentage based subjects like that. They can be with you, so you've got masters, and then actually the final bit like the costs associated with we also do it too. There's a number of things out there, but the family
They're very large.
Yeah.
As long as your files are
That was the other thing I was going to say. So basically, you have to hand over the files to him, and in any large scale stages or things, for example, we give an the ownership which we keep, and when I sort of attended those, which I think is fascinating to them. So I handed over all of my attendance notes to him, plus the hard copy files such as the correspondence orders, all of our emails. We did a USB for him. He's perfectly happy to have it in USB, but he also has to do the structure that he can ready to do anything to it. It has to use a bit of practice for us in our TM system because it loads all of the dates and emails. So we then go through and basically retitle everything. Which is something the quite he said he found it quite emails and what you thought, but obviously it's your privilege files, so they're actually doing. I don't think you want to those I can get. Of course you don't. It's just yes, but also being in the bill of course you got so much analysis that privilege material is effectively exposed, particularly if you've got CI competition. Is there anything else on the taxation side?
No. Okay. All right. So that just leaves just a quick word on litigants in person. Apparently, litigants in person in Guernsey cannot recover the costs of preparing or presenting their case, which is different from the position in England and Wales. Since 1975, there's been a statute there that allowed litigants in person to recover their costs, admittedly at a fairly low rate. I think it's currently, according to Neil and Featherstone, currently £18.50 per hour. Peanuts, obviously, but at least they can get something. But as was noted in Neil and Featherstone, in Guernsey, the matter is very different. Different in the sense that they can't recover any costs. So out-of-pocket expenses, yes, and for like copying, stuff like that. But no, they cannot recover their costs. So, yeah, Mark was talking about it yesterday. Yeah. Okay, good. Right. Okay, so chapter 17. I don't want to get ahead of myself, but I'm kind of looking at the clock. It's 5 to 12. We've got about 40 pages left, 3 chapters, 40 pages to get through. I kind of think we could finish by about 1. Yeah, just call it a day then.
Yeah, I mean, I have seen people calling out, but more as a head of damages. That's trust fees, that's very different. So in trust proceedings, if you've got an individual, it's going to be 2006, it's something like the 25th of November 2015 was the first judgment, and then there was a subsequent one in Shendy's, where he was the protector and he claimed that he was entitled to remuneration. Is that the one you're thinking of?
Yeah, which I know is different to being a litigant in person because he's not actually conducting litigation, but effectively he's being the sort of as a sort of in-house advisor to, and he was he like, I think he got like a flat fee or something, which wasn't anywhere near what he claimed.
He did, but he was there claiming remuneration of a protector to the trust under charging clause of no, it's
Okay. On to you, all right?
Yeah, I'm just going to go like
okay. All right. Chapter 17 then. Enforcement of judgments. So obviously the key point really is you've got to be able to enforce your judgment, otherwise what was the point? We've just been paying lawyers for no good reason. So as it says, we need to be a bit careful about prescription with this. So at the end of 17.1 you can see consent order becomes prescribed after 3 years, whilst a default judgment manages to last for 6. Although, yeah, I think so, yeah.
That's why people don't generally agree.
To consent orders, yeah, because you want the extra time. Yeah. But in either event, you can apply for extension as long as you get it before the deadline has arrived at. All right, arrets, we did, I think, look at those in a reasonable amount of detail when we looked at chapter 5. So I don't think that we need to particularly revisit that. I think it's just a summary in 17 anyway. So SASE we definitely didn't look at last time. So we need to think about that. So there's a contrast there. So the ARET looks at personalty, but SASE is dealing with realty there. And as you can see, creditor needs to make an application for leave to proceed. And if you, yeah. There is, but off the top of my head, I can't think what it is. Well, 6 years. Yeah, I mean, that sounds right, but I can't. No. Yes, okay. I mean, that is an important point, and I'll see if I can follow up on that. Yeah, okay. So, all right. As we can see, then careful thought needs to be given because once you have applied for SASE, then you lose your right to pursue personalty. Perito and Kurth decision from 2004, which is generally quite informative on this whole area, really, says that was an can't even say it, irrevocable election. So that's what you have. So first point then, as it says 17.7, is what's your evidence for the debt existing? So there could be a bond, there could be a loan agreement, or as far as I guess we're usually going to be concerned with enforcement, a judgment debt. If it isn't secured, then, as it says, obtain judgment there if the debt isn't already the form of judgment. Register it in the Livre des Hypothèques at the Greffe. Once there, as it says, you get an element of priority, and you can register the claim before there's been a judgment, as soon as it's placed onto the pleadings list. A form of security, and you can see the Guernsey Bar website says the world at large is bound by what appears in the book from the date of entry, which is great, except the book can then be amended, and you've got an example of that in the Channel Islands cream liqueurs case. So, but to be fair, as you can see, there was a condition imposed there that a sum equal to the plaintiff's claim should be lodged with the greffier pending conclusion. So, in that sense, the amount was still, the plaintiff still had some security as far as their claim is concerned. But there is a balance, as it says, trying to strike a balance between the desire of a potential creditor to protect himself, to protect the assets that he's seeking to enforce the judgment against, or enforce the debt against the right of the debtor or potential debtor, if it's going to arise from an action, to deal freely with his property. What else do we need to think about? Nothing in there, I think, as far as yes. Oh. Yeah. I think it's an extremely powerful tool. Yeah. Mm.
In theory, is entitled to maintain, retain any equity and abandon debt. And I know the court deals with that and expecting an undertaking from the creditor concerned to pay the balance over to the next creditor in manner. As a process to be on. Unfortunately, the one case which I thought would be
no, it's not ideal. No. Okay, so what do we need to think about? Yes, 17.8. Ascertain the extent of the debtor's property holding. Will there be sufficient equity to satisfy the debt, or indeed, if there are several creditors, that of the principal creditor? So you need to, as it says, determine if there are other secured creditors, because the outcome of that inquiry may mean that it's just not worth taking part in the SASE proceedings. Yeah. Yeah. Oh yeah, yeah.
You do your phone search, very carefully here as to because we have multiple companies which are used to which we forward. It's a lesson we very careful about. As it happens, if we've got somebody who is using one corporate vehicle per property, that's great. Other creditors involved.
Okay, so proceedings, I think it's fairly straightforward. You can see there are 3 stages there. You've got this, the SASE procedure simplification bailiwick order from 1952. It has been amended, but I think the Pareto and Kurth judgment makes the point that that order didn't really change the law as such. It just made it easier to kind of track it down because it's essentially customary law that one is looking at there. So you've got your three basic stages there. So get a preliminary vesting order. It has an alternative name. Then move to get an interim vesting order, ditto, and then move to a final vesting order, assuming that the debts have not been satisfied before we've got to that point. So as I say, I think it's fairly straightforward. There's going to be a commissioner appointed by the court. The debtor has to be given notice to appear, and yeah, the court will eventually make, if it makes an interim vesting order. That's the important point, because at that stage, then the whole of the debtor's realty becomes vested in the creditor as a trustee for the claims against the realty. And the effect, as it says there, is to completely extinguish any right in or title to the realty that the debtor had. And you've got a case in the footnote there, don't know what number it is, but it's the 15th footnote in this chapter of Trimby against Atlantic Holdings Limited. And that was a very unfortunate case, I think, where the court was moving towards a final vesting order. And I think it's Mr. Smith, if memory serves me. I think Smith was the unfortunate party there, because he got judgment against the company for £5 million. Anyway, he got a significant judgment in his favour, but really just wanted it was a hotel. He wanted to get back in the hotel and resume his business. And the court made the point that since there'd already been an interim vesting order, the hotel had gone to the creditor. And that kind of comes back to your point about surplus. Yeah.
Preliminary, I think you would then immediately have to ensure,
and you'll want to get what's most valuable
Okay, so I think we could probably move on to the stuff on disaster proceedings at this point then. So again, like SASE, this is essentially customary law, but unlike SASE, this applies to personalty. It's not available for PDC judgments. Creditor can apply to set disaster proceedings in motion as long as the debtor has assets to satisfy an outstanding debt, and that may mean that the creditor comes back from time to time until the debt is extinguished, assuming that the debtor acquires more assets or other assets are discovered that weren't originally known to exist, and that's possible because there's no kind of full and frank disclosure obligation on the debtor as far as these proceedings are concerned. So as long as there is some portion of the debt still outstanding, then the debtor is still, if you like, in jeopardy of having fresh disaster proceedings commenced. And the only way to stop that is if either the cause of action itself becomes prescribed or the judgment becomes prescribed, which gets us back to Jasmine's point. So I need to nail that one down. But as I say, there's no obligation to make full disclosure. The procedure would begin with an arret. That would either be an arret conservatoire, so you haven't yet obtained your judgment, or an arret execution, so you have your judgment. You'd pass a certified copy of the Act of Court to the sheriff, who would then make an inventory and take walking possession of enough assets as in their estimation would be necessary to discharge the debt. And usually you get an undertaking, you seek an undertaking anyway, from the defendant not to sell or otherwise dispose of the assets. But it's important to note that this is not like a freezing order. So technically speaking, the defendant is still can sell the goods and potentially at least could pass good title in them. So if the court subsequently confirms the arret, then there'll be a public auction where the sheriff can sell the goods. Has to publish a notice in La Gazette Officielle because you need to notify or alert other possible creditors of the debtor. Once the auction has taken place and the money has been got in, then there'll be a summons issued by the creditor for the sheriff to pay him his money out of the proceeds. But of course, it's possible that other creditors have in the meantime come forwards as a result of the notice in the official gazette. And the question then arises as to what's going to happen if their debts cannot be covered by the proceeds of sale. It would seem to be that this marks the start of the disaster proceedings. There is, I think the text probably raises a query there. I think it's in 17.18. Do you need to have multiple judgment debtors, or can you just have non-court based debts? And I think it seems like the latter is the practice there. So if all of the debts can be, if all of the debts that have been identified as a result of this process can be paid from the proceeds of sale, then of course that's what happens, the end. But if the debts can't be covered, then the sheriff will state that fact in his reply to the creditor's summons, and that's effectively where the disaster proceedings themselves kick in. So we're moving from that arret situation into disaster. In that situation, the court will appoint a commissioner. Commissioner orders the arresting creditor, the one who had the arret, all other creditors that they're aware of, and the debtor to appear at the creditors' meeting. There'll be an interim hearing where the arresting creditor can apply to have the debtor declared on disaster. Again, notice of the creditors' meeting will be given in the official gazette and also apparently displayed in the vestibule of the court building. And then the commissioner will undertake what's known as marshalling of the debts and setting out this order of preference for the application of the money to go to pay them. The commissioner has the power under the 2006 Miscellaneous Provisions Law, Section 8, to require any creditors to provide such evidence, information and documents in support of their claim or preference. So that could include, it is said in Section 8, evidence by affidavit. The debtor can say which debts he accepts or which he agrees. Preferences, which are covered at 17.20. So if you looked at the preferred debts law from 1983 and also the preferred debts disaster procedures and miscellaneous provisions, etc., law from 2006, you will get, I think, in that list of small 1 through to 5, you will get 3, 4, and 5 from that. You won't get 1 and 2 from that, but essentially, hold on, actually, you'll certainly get little 1 from that. I take that back. So I don't think you'll get 2. Little 1 you can get from Section 6 of the 1983 law. So that provides for the court may make such order as to the payment of costs or the fees and expenses, and as to priority to be given to such costs, fees, and expenses as the court may consider to be just. So costs of the disaster proceedings are number 1 priority, then the cost of the arresting creditor, then everybody else's costs. Secured debts, it seems to me that these almost kind of fall outside of all of this because, as it says, they'll be secured on arrested personality. that seems to be likely to be quite a rare eventuality, because people generally don't take security on personality because it's too movable and disposable. But as it says, you may have a situation maybe with a pawnbroker. You've pledged goods in return for a sum of money. As it says there, somebody who's got security through a pledge of goods has possession already and can just sell them. They don't fall within the pool of property that is available for the disaster proceedings. You've also got this rather specialist situation of the landlord hypothecation, tacit hypothecation, which arises under customary law to satisfy rent arrears. Again, Bell Systems and Moffat is quite a nice little case, I think, to kind of get your head into what's going on here. It does kind of paint a rather nice picture of the sheriff rocking up to premises to take walking possession of things, and lots of other people rushing in to say that's mine, that's not his, I bought that, etc. I think in Bell Systems, somebody had come along, a third party, said they bought stuff about a year ago from the debtor, and they slapped sticky labels on various items that they said were theirs. Not sure the sheriff took much notice of those sticky labels, actually. But, so that is that. As it says, any property found on the specified premises for tacit hypothecation, we have to go through that same process. Notice in the official Gazette, and as you can see, if someone does come along, like the guy with the sticky labels in Bell Systems, then they have the burden of proving their ownership before the court. So it's not incumbent on the sheriff to do that. Tools of the business, that sort of thing. Yeah.
And you may find that you get a question around it, people who section much more courses in order to do. I think it's been said in the section, but then they go on and do specific ones. One of that, I know this is under the achievement specified. Insofar as it's a disproportionate fees because of the hotel or any of the kit that we need for these people in. Don't do anything else in there.
Yeah. Well, you can kind of see that from all these points, these details of was it the wages and salaries of clerks or other servants, wages of workmen. Yeah. Okay. Right. Well, speak for yourself. But yes, there we are. Yeah, I think the whole thing's a bit okay. Well, you can see this reference by the deputy bailiff in Bell Systems to the deadline for what is it? Your third-party purchaser claims to be a bona fide purchase for value. Says that on the face of it, it seems to be a bit harsh. Perhaps worthy of a more equitable solution being found in time. Equity doesn't really seem to be a big consideration in this area. Yeah.
Yeah. Again, it's a bit like the take back the equity stuff. I think the sheriff is quite. They're like that, yeah. It's not satisfactory from a human rights law perspective, but it's
Self-regulate.
Convention for equality and non-discrimination against women, on those that sign up to the partially through implementation.
No, Clint. Take your time, think carefully. Yeah. Okay, all right. So appeals, chapter 18. So we've got two basic courts to think about: the ordinary court when it's hearing appeals, and then obviously the Court of Appeal. In the ordinary court, that may be constituted by the bailiff sitting alone or with jurats. There is a right to appeal if the amount of the debt or the damages that are being claimed is in excess of £200, or if a point of law is involved. Procedurally, I think that's all pretty clear from 18.3. Nothing really to point out as far as that's concerned. There is a notice that has to be filled in, and very unusually for me, I have included that notice exactly as it appears in the schedule. And as I've noted in that footnote there, it does say the determination of the Magistrates' Court made on the blank day of blank 20 something or the other. And that's what it says in the form, because that's when the law was made, slap in the middle pretty much of the 20th century. Obviously, that would need to be amended now. So, no, what am I talking about? I've amended it. Sorry, I've amended it. Yeah. Well, or time frame. Yeah. Why did I do that? I don't know. Taking it upon myself. Yeah. What was I thinking? As we will see in various places in Chapter 18, the respondent can apply to the court for an order to have security for his costs on the appeal. What, the form? Yeah. Because I was conscious, I think this is one of the later chapters that I did, and I was kind of conscious of there should have been more, and if I was doing this again now, I'd be putting in maybe more forms and more kind of paragraphs from judgments, because I think I tried to keep it clean, if you like, but I think probably on reflection, I've been too editorial with that sort of thing. So, and I think I was beginning to shift a bit towards the end. So some more kind of material from the cold face, as it were, rather than just me trying to summarize it and keep it nice and short and tidy. Yeah, sorry, Elaine.
Along with some of the more basic practice, prior to someone's arrest, sergeant, and those sorts of things, which I'm happy to.
Yeah, thank you. Yeah.
But that is just the basics. So I've got, for example, application notice, signification, your summons, your calls, your disclosure list. I mean, this is all when I did it, so it's a little bit like that.
Yeah, no, that'd be brilliant. Thank you. Yeah, good. Okay, so abandoning one's appeal, again, that comes up both here and going to the Court of Appeal as well. So not less than 2 clear days before the hearing date, you can abandon by giving notice to the greffier. At that point, of course, then the respondent will be looking to enforce the original order that you were appealing against, and may indeed apply for the costs, their costs on the appeal to date. As is usual with costs, the court has the power to make such order as is just and reasonable. On the appeal, in terms of powers, so 18.6, the court's powers are again the very standard ones to confirm, reverse, or vary the original order, or indeed make such other order as it thinks fit. In terms of its approach to life, it's not supposed to interfere with the exercise of discretion in the Magistrates' Court unless it's clear that the judge there has misunderstood the law or the evidence, or has drawn a wrong inference from the facts, or there's been a material change in circumstances since the original hearing. And I think the case on that is A against B. Also, the ordinary court shouldn't overturn findings of fact that have been made in the magistrate's court unless either there's no evidence on which to base that finding or it was obviously perverse for other reasons. Mm.
In some magistrate's court, ongoing court website guidance note that if I'm interested in relation to the court, which talks about corporate entities represented by the director. I remember after I was working on here, the secretary of the country was a corporate entity and an individual in employment of that corporate entity. The jury of thousands of arrests like that up on Thursday, and I can't remember who it was, which magistrate from who we accused here, and basically called over and said it's quite a nice case I'll call over and just keep getting back to here and then of course this was not possible, so we eventually faced him and we were found against the judgment against the defendant company. So we ended up appealing, and I did the appeal before the Secretary in the ordinary court. And one of his points was, well, first of all, we accepted that defendant gave the impression that trivial person and therefore it would be wrong not to permit that to happen. So it was wrong not to allow him to speak. But the other thing he made points out, of course, was doing all the inherent power of the magistrate's court, and that sounds like it's not inherent power because it's a piece of statute. So it's more the power of the statute that created it. So I think it's just important to bear that in mind, that it's in contrast to the one court, it is a piece of statute.
What was the actual issue that he wasn't an advocate?
Yeah. There wasn't, I think that had been, for example, partnership or partnership. There's the fact that it was an individual person in circumstances. The direction is actually on corporate entities as well. Right. So it's the kind of derivative. We really get to the point where you've got somebody to do the authorized and legislative will be used. Right. So the DB did say that things is very we've got the appeal process, so we also want to which is trying to minimize for it to
So there's in that instance, other than you guys appealing for the company, there was no way I could have.
Phil Roby was not. He was wrong.
Yeah.
Okay, all right. So, any further appeal obviously goes up to the Court of Appeal, and then we need to think about Court of Alderney. So there's a right to appeal on any civil matter to the ordinary court unless statute has already provided that the court's decision is final. Leave to appeal is needed if either the value of the dispute is £25 or under, unless there's a question of law involved. Imagine that. But it's also needed if you're appealing against a consent order, fairly standard, or against a costs order. As far as the procedure is concerned, that's set out in 18.10. There's nothing particularly significant there. We note that you have to state your grounds of appeal. You also have to indicate whether you're appealing against the entirety of the order or only a part of it. And again, standard, respondent can apply for security for their costs. 18.11, you can abandon. Again, that's not less than 2 clear days before the hearing date. Powers of the court, it can confirm, reverse, vary, or make such other order as it thinks fit. So that's exactly the same as with appeals from the PDC. You have an example there, Hawkins and Green. I don't think there's anything particularly interesting about that. It's just an example of an appeal that went from Alderney to the ordinary court. And then you've got the Court of the Seneschal of Sark, and that's covered by the Reformed Sark Law, section 19, which says there shall be a right of appeal from the court in civil matters to the royal court sitting as an ordinary court. There is apparently a 40-day time limit to give notice of appeal. It has been suggested that that could be cut down. You can see the reference there to the De Carteret case, and that 28 days might be a more practical or sensible period of time, but that you couldn't just kind of introduce that by possibly disenfranchising a would-be appellant. So yeah, so I think it still stands as 40 days. Obviously, if the seneschal or the court decided to cut it down, and they said that at the time of giving judgment, I think that would probably go without any comment or criticism. But there you go. Again, any further appeal to the Court of Appeal, and then potentially on to the JCPC. All right, Royal Court to the Court of Appeal. Again, you've got a combination of either appeals by right or appeals with leave. If there's a point of law involved, or the value of the claim this time is more than £200, then you have appeal by right. In all other situations, it's with leave. You have a month to file and serve your notice of appeal on everybody. You'll have an odd number of judges sitting, so that we don't end up with a split court. We should also note that a single judge can exercise quite substantial powers in the Court of Appeal. So, for example, can give leave to appeal where it's necessary to get that, can extend the time within which the notice of appeal has to be given, or an application for leave to appeal is being sought. And in any pending appeal, the single judge can rule on any matter that is incidental to the decision other than the decision itself, and can make any interim order to prevent prejudice to the claims of any parties pending as he thinks fit. So single judge has very wide ranging powers there, really pretty much anything except determining the appeal itself. Yeah.
But the other thing, this may be slightly and review, so apologies if it is, but in the case in 2015, the NVE, which basically is all to do with a trust dispute, but it was refinancing of the trust asset at a family home. I remember we did the leave to, there was some suggestion of urgency because of mortgage facilities and assets. And we were objecting to that happening. The Court of Appeal, well, basically the other parties went to and got an abbreviated time people for the appeal process on the basis of commercial urgency. So will the appeal deadlines are there, it's also a possibility to have that ability. And it was done again in the 2013. 11th to 12th December 2013 judgment in Best Central Allow, which was to do with stays executions and execution costs, which I think is something like judgment 7 2014. That was all just about working at the
No, that's extremely important. Yeah. Okay. Right, what else we need to note? Oh yeah, there may be circumstances where it's a statutory matter and statute provides that the decision is going to be final, in which case it is, end of. No point worrying about that. As far as applications for leave are concerned, there's a distinction to be drawn whether we are looking at a final or an interlocutory decision, and that's covered in 18.18. A decision is final, and therefore you wouldn't need leave if it totally disposes of the matter, whichever way it gets decided. But if it would not dispose of the matter, if it was decided one particular way, then it's interlocutory, and you have to get leave to bring your appeal. Grounds of appeal, curiously, there are no statutory grounds of appeal, but it is understood, I think, that it's either the decision below was wrong in law, or there's been a wrong exercise of discretion, which might be an error of principle. It's very standard, taking irrelevant stuff into account, ignoring relevant stuff, or the decision is plainly wrong. The Court of Appeal is not formally bound by its previous decisions, but there'd be an assumption that it would usually follow those decisions. And I think we had an example from Mark yesterday where we had a five-judge Court of Appeal, just to kind of boost up their credibility. But as I think we kind of discussed this at the first study weekend, how would they know? How would they know that they needed 5 judges? Because they were going to be changing what the law is, kind of chicken and egg situation, really. Yeah. Yeah.
Effectively had a set of case management provisions at the appellate level, just to manage that there were several different issues and
Yeah.
how we should be
managed. Okay. Right. Okay. What else do we need to think about? Oh yeah, okay. So procedure, again, I think is fairly straightforward, dealt with in 1821, but we should also perhaps notice in 1822 that a respondent may themselves not just be defending the original order or decision below. The respondent themselves may wish to suggest that the decision should be varied, or indeed to suggest that there are either extra grounds or just different grounds for upholding the original decision. Respondent is entirely at liberty to do that, but has to give notice to that effect, specifying the grounds and the reasons for any new order that's being proposed in the case of a variation. Aside from that, powers of the court at 1826, usual sorts of things that you'd expect to be there. Court can receive fresh evidence, has a discretion to do that. It can draw any inferences that it thinks are appropriate. It can give any judgment that ought to have been given originally, or make any order that ought to have been made. Again, can order security for costs to be given by the appellant. It can even go to the extent of ordering a new trial, in obviously fairly extreme circumstances. Or what? Security for costs to be given by the appellant?
Oh, by the
Yeah, sorry. Did I not?
Sorry, no,
So,
that's fine.
okay, all right. And last point, really, as far as this is concerned, stay of execution. So I guess the key point there really is that putting in a notice of appeal of itself doesn't automatically exercise or operate to stay execution of the judgment below. So you'd have to specifically apply for that. You could apply either at the court whose decision you're appealing against, or you could apply the Court of Appeal itself. There is a threshold test. So the grounds of appeal would have to have some substance and be thought to have been made in good faith. So in other words, this isn't just kind of putting off the evil day, but there's a legitimate basis for an appeal. The court would then have to balance the risk of injustice to either party, depending on whether it granted the stay or didn't do that. All right, last part of chapter 18 then is our old friend going to the Judicial Committee. I don't think I've got anything new to say about that. Sorry, Elaine. Yes.
that one, but it was a circle.
Yeah. No, it's always good to have someone else's view on that. No. Yeah. Carry on. Yeah.
Permission.
Hmm. Mm-hmm.
So does that come in with, or
Yeah.
does it be with what others have said?
Times with.
But it's obviously an area that one would imagine will develop, or perhaps not. I mean, who knows?
Yeah. Yeah.
You think?
I think it's one for,
I don't know, if there are people who may not have an interest in doing it and check it all out, but there may be others who don't check it and don't appreciate.
it's featured quite prominently in data set as well.
Right.
So it could be like that. Good for us, but actually.
Back to you all about it.
I think that, I should have a question on that before we
Why not? Yeah.
You guys get to say what you want.
Vote now.
Yeah. No. That's really helpful. Thank you.
I
Right.
actually think that that's the
Yeah.
only case I've read so far. Actually.
Yeah.
And then I read it, and it was the most disappointing judgment I've read. There's only about 2 paragraphs that matter. And the one that matters, bunch that you touched on.
Yeah. Yeah. Well, there we are. Yes.
Yeah.
Yeah. It's,
But if I actually just copied out the paragraph, you know, no point I wrote it down. It's 11. That's paragraph 11. Yeah, that's it. Seriously, I didn't write it down. Oh, just 13. Oh.
wow. Right.
I was bracing myself for like a big reading session.
Yeah.
I was like, oh, it's just one.
Yeah. But you didn't realize that until you'd read everything. Yeah.
I'm curious.
Yeah.
Yes. Yeah.
And how do you remember all
I'm
that?
joking.
Well, when you've got a feel of it, it can be more interesting when the movies, Rio and Lorraine, there's various ones that just come up again and again. Now you're going back in my car and also have what I thought was cases. Happy to send it to you for what it's worth, but it's 10 years out of date. But I do think that I certainly can function to
Yes.
look at. And also you just get a much better identity stuff. Some of it is just not in the rules. And it sucks because it's so hard to work out, you're supposed to stand up when at different bits, you're freeze up and freeze up with all this kind of stuff that's unwritten. It's crazy.
Especially those Scottish accents, we get into trouble.
Not as much as Anthony Williams gets into trouble in a bit of Marshall with his accent.
So, I mean, H. I'll look at it, such as it is.
Right, chapter 19, and then we're free. Okay.
What, and then we're going to finish?
Well, unless you've got some other chapters that.
I thought we were going to go over today.
Yeah. Well, no, I think I did say it's because this is the first time I've done it. It's been very difficult to kind of assess how to. Yeah. Yeah. All right. So yes. Yeah. Tuck in now. Yeah. You still got your apple there. Look. Okay, so yes, international judicial cooperation. Largely, not exclusively, but largely looking at the use of evidence or provision of evidence, obtaining evidence. So divided up into either providing evidence here for use not here, or vice versa. So we'll start with providing evidence here to be used outside of the jurisdiction. So as you can see, distinction between, and this is a common kind of theme here, distinction between a willing witness and an unwilling witness. So as it says, if there's a willing witness, typically no need to involve the court there at all. Maybe possible, this is something that I've nicked from the Guide to Letters of Request from the Treasury Solicitor in England and Wales, but I think it's equally valid there. Where the witness is willing to give evidence, it may be possible for arrangements to be made for him to attend before a consular officer or an examiner from the country where the litigation is taking place, and thus may be obtained without seeking the assistance of the authorities. So the problem arises where you have an unwilling witness, and then we're looking at the, as you can see, this 1980 order, which is extending provisions to the bailiwick of a UK statute, the Evidence Proceedings in Other Jurisdictions Act 1975, from a time when obviously the parliamentary draftsman was operating on a Ronseal basis. So it has to do exactly what it says on the tin. Anyway, so those provisions were extended but slightly modified by the relevant SI, which I've cited in that footnote there for you. As far as the procedure is concerned, then we're looking for the requesting state either being a party to the Hague Convention or having a bilateral agreement with the bailiwick, or neither of the above, because all three of those are possibilities in terms of invoking the relevant procedure. And you've got some reference there to the comity or cooperation between different countries. So, as it says, I think it's all pretty straightforward in terms of the letters of request there. You will note just something that I was thinking about last night. The Republic of South Africa versus Dutton. It's quite an old case there, 1992, but you can see there a commission rogatoire was sent through by the Supreme Court of South Africa, which included a request that South African counsel be allowed to appear before the commissioner and examine the witnesses, which is of course not quite the same as appearing in court. It's not like having right of audience as such there. You can see that the court had the power to accede to that request if it thought it was appropriate, and indeed it did accede to that request, but with a caveat that I've missed out the P there, each party also had to instruct a Guernsey advocate who would have overall control of their client's case, and also the foreign counsel couldn't seek remuneration, so there wouldn't be any costs significance there. Not sure whether that was the not the costs point, but the caveat about instructing Guernsey advocate was a kind of a more proper point from the bailiff there, rather than anything kind of more significant or practical. Privilege 19.7. Again, you can see there the witness, our reluctant witness, cannot be compelled, so they can stay reluctant. It can't be compelled to give any evidence. They couldn't be compelled to give either in civil proceedings that would be brought by in the appropriate court here, which would include the Court of the Seneschal and also the Court of Alderney, or in civil proceedings of the country where the requesting court is based. And that's, as it says, either if his claim to privilege is supported by a statement in the letter of request, so the requesting court has acknowledged the existence of certain privileges, or is conceded by the applicant. If the claim to privilege is based on the law of the requesting court, but it doesn't meet those conditions, in other words, it's not accepted or acknowledged, then the witness will be required to give the evidence, but it would be withheld until the requesting court has addressed the claim to privilege there. So that's basically that. Powers of the appropriate court within the bailiwick. You can see there are 5 different possibilities in there, including the interesting one at little 5, person be medically examined, including taking samples from them. But there is a limit, 19.9, there is a limit to what the court can do. So it shouldn't make any order that it couldn't make for itself, basically. So within its own proceedings in that court. No power to order general discovery, so no fishing expeditions, as it says there. I don't think there's anything else that I need to say about that. So the other side of that coin starts at 19.10 then, which is evidence being sought outside the bailiwick for use of proceedings internally, and it's suggested that the best method there will simply be to use a live link, but that, I guess, partly depends on whether the witness is a willing or an unwilling witness. So the unwilling witness, there'll be a letter of request or commission rogatoire. As it says there, identifying the foreign court, sorry, 19.12, identifying the foreign court or some other relevant authority in the country where the request is being made, and asking that it makes an order for, I mean, this is basically the same with the shoe on the other foot, effectively. No prescribed form for a letter of request, which is a shame because you'd like to think there might have been, but apparently not. In order to, it says it's appropriate to meet the requirements of the Hague Convention. If it was going to do that, then those are the things that it should be covering. Okay, and I think the last few points that we need to think about will be enforcement of judgments. So from 19.13, there are 2 different schemes as far as this is concerned. There's a statutory scheme under the Judgments Reciprocal Enforcement Guernsey Law of 1957, or common law. The statutory scheme kicks off at 19.15, and as you can see, the reciprocating country is listed there, or are listed there, along with their superior courts. There are apparently 10 of them at the moment, so you have the relevant ones all set out there. And there are statutory criteria listed at 19.16. So foreign judgment must have been given by a superior court from a reciprocating country. The judgment itself must be final and conclusive, so no appeal going on there. And there must be a sum of money that is payable, so that's what you're seeking to enforce. Taxes, fines, and other penalties generally are excluded from the remit of this particular law. So it says that the judgment will be finally conclusive even where an appeal is pending, or it may still be appealed. Yeah, okay, I think that's that really. Procedure 19.7, sorry, Elaine, yes. Mm.
Yeah.
Case of the lead, it's case of the lead, it's case of the lead court. I can't remember its name. You can try like transferring it after you.
Oh,
If you
okay.
get judgment in the lead county court. Yeah.
Yeah,
Well,
okay.
yeah, if you get a county court judgment, there's an application, there's a procedure where you can transfer it up to the High Court, which then makes it registrable in its own jurisdiction. and there's a case in Guernsey that says that's okay. Because some of
Probably
the,
against the big stamp duty. Because it's one of those ones that we have interest in, we're dealing with it.
Yeah, okay. Good, good, no, thank you. Right. Procedure is covered ad nauseam from 1917 to 1921. I don't think it's going to serve any purpose to plough through that, but the registration itself can be set aside. So somebody, it says against whom a registered judgment is going to be enforced can apply for it to be set aside at 19.22. And you've got criteria there, 5 different examples of criteria that could be used by the, I'm going to say victim party, I can't think of a better way to put it. The party's going to have to pay up under the foreign judgment, which probably means they're not a victim at all, really. Okay, nothing else really, I think, to say about that, except you can see the powers at 19.25. So if the person that's seeking the set-aside satisfies the court that an appeal is pending or that he's entitled to appeal and intends to do so, then the court can basically defer its decision about registration or the application. So as it says there, it will wait either for the appeal to be disposed of or wait until the time period, if it hasn't actually been initiated yet, wait for the time limit to elapse on that and then crack on if nothing else has been done. All right, common law, that will apply if we are outside of the statutory scheme. So judgments from a country that isn't on the list of reciprocal countries, or it is on the list but it comes from an inferior court, which kind of gets us back to your county court observation there. Also applies to fines and penalties, which were excluded from the statutory scheme, and also applies where, as you can see, enforcement is being sought in Alderney or Sark because they are not covered by the 1957 law and the statutory instrument. So that is that. So 19.29, a common law, what happens is that you're suing as if you had a debt there, treating the judgment as the cause of action. So no need for any new trial. It is suggested that this may be cheaper than going through the statutory scheme. There's no way to contest the original judgment on its merits. Obviously, that was the purpose of having an appeal procedure and the original forum. So the only question really is a jurisdictional matter, and you've got some points to consider as far as that's concerned. I think that's basically that. I did notice, probably wishful thinking, that gin had crept in to 19.30. Yes, gin in the vein, yes. Don't know what was in my mind at that point, really. But, okay, and yes, enforcement. 19.31, enforcement within the bailiwick is done by Her Majesty's Sheriff, and it doesn't matter whether that's under the statutory scheme or common law. You can see there potential for disaster proceedings if necessary, or so all the stuff that we were looking at in chapter 17, and enforcement of Guernsey judgments in foreign courts. Take your pick, as it says there, outside of the scope of this guide. Hooray! Local lawyers may need to be consulted. Yeah, fan. Yeah, okay. Wow. Yeah. Yes. Yeah. Yes. Yeah. Well, yeah, just, mass hysteria about everything, really, was it? Stockpiling medicines. I've got my corn plasters, all sorts of things. Yeah. Right. No, thank you so much. So much for coming. Yeah. Yeah, okay. Right, and you can go back to your menagerie. Hey. Yeah. Yes. What is the panto? Ooh, okay. Hey. It's a bit sexist, isn't it? A bit sexist. Merry band, surely. Merry band, merry group. Not merry men. Someone was telling me the other day that apparently a lot of pantos are employing children these days. They're doing a production of Snow White. They're employing children because it's cheaper to do that than get specialist short people in. Yeah.
The wedding.
Really? How surprising. Yeah. Drag their kids down a bit, yeah. Yeah. Right. No, no, thank you. Oh, I'm sure it wasn't. Right. Well, to be honest, I had no idea. Well, I hadn't been told that anybody was. And then it's a bit weird because there was this conversation. Did you? Oh, right. Well, no, I never heard anything. No, okay. But as I was saying to these guys yesterday, that I had a message from what's the name? Rosalind, Mark's PA, I think. Could be, yes, that's his move. Yeah, sorry. Oh, yes, let's.